Hello everyone, welcome back to Elite Academy and welcome back to our daily issue analysis. And today again we have come up with a very important topic which is there in news. So let's start our discussion. Hope you all had good times yesterday and you are doing good with respect to your studies. You are revising well. In case of any problem, do reach out to us. You must be having our Telegram ID, our email ID, our phone number is there on our website www.eliteacademy.in. Okay. Okay, so let's start our discussion. So today we are going to discuss about money laundering and why money laundering is in news. Money laundering is in news because Supreme Court has recently upheld power of arrest, raids, seizure under PMLA, that is Prevention of Money Laundering Act 2002. So under that, the powers of arrest, raid, seizure has been upholded by Supreme Court, and the name of the case is Vijay Madan Lal Chaudhary versus Union of India. So you just remember Vijay Madan Lal Chaudhary judgment. Supreme Court has said all these things. So we will discuss in detail. Then you will get further more clarity. So before we discuss the provisions or the issues related to the case or the provisions of PMLA, first let's understand what is money laundering. So money laundering is a process, it is the illegal process of making large amounts of money. To be very precise and simple, money laundering is the illegal process of making large amounts of money. And this money is generated by a criminal activity that may appear to come from a legitimate source. So the source might appear that it is coming legitimately, but it is coming from a criminal activity. So criminal activity can include drug trafficking, terrorist funding, illegal arms sales, smuggling, prostitution rings, insider trading, bribery, computer fraud, anything, okay, that produce large profits. So this is money laundering definition for us. And what Supreme Court has told with respect to this, Supreme Court is saying that money laundering is an offense against the sovereignty and integrity of the country. So the case which we have discussed on the previous slide, in the same case, in Vijay Madan Lal Chaudhary case, Supreme Court is saying that money laundering is an offense against sovereignty and integrity of the country. And in the same case, they have also told that the offense of money laundering is no less a heinous offense than offense of terrorism. So that is how they have equated it, that this crime is a heinous crime, it is a heinous offense and it is equivalent to the offense of terrorism. So that is the gravity with which Supreme Court is seeing this whole aspect of money laundering. Okay, let's understand the other aspects. In money laundering, there are various stages. First stage is the placement, where the illegal money enters the financial system. So here the money is injected into the formal financial system. Okay, the second one is layering. Here the injected into the system, whatever money has been injected into the system is layered and spread over various transactions and bookkeeping tricks to hide the source of origin. So it will be layered over period, it will be spaced out over a period of time or space, and it will be injected in such a manner that the layering will happen in such a manner that it will be spread over various transactions. It will be not like a bulk amount, and the bookkeeping tricks will be used to hide the source of origin. And the third stage is of integration, where the laundered money is withdrawn from the legitimate account to be used for criminal purposes. So the funds are being used to purchase luxury items for investment, or where now the money has entered into the financial system in such a way that the original association with the crime is disassociated, and the money now can be used by the offender as a legitimate money. However, that is illegal money. So we know that from where it is coming. So illegal money is being placed, then layered, then integrated. So this is the pictorial representation of the three stage of money laundering that we have discussed. Okay, now we will discuss the PMLA issue, because of which the whole Supreme Court judgment is there, and what are the provisions and why it is in news. So we have PMLA Act, that is Prevention of Money Laundering Act, and Enforcement Directorate, that is ED, is responsible for the enforcement of this particular act. And under PMLA, ED has been given many powers. Okay, so PMLA Enforcement Directorate says that PMLA is an act to prevent money laundering and to provide for confiscation of property. Okay, so there are offenses which has been described under this, and punishment, norms for arrest and bail. So we will discuss few of the provisions. So it talks about, with respect to punishment, that according to this act, the person shall be punishable with rigorous imprisonment and not less than, which shall be not less than 3 years, but which may extend up to 7 years, beside a fine. So it is talking about this. With respect to arrest, this act is talking about that the senior officials authorized by central government may arrest a person if they have, on the basis of material in their possession, they have reasons to believe, and that to be recorded in writing, that he or she has been found guilty of an offence punishable under PMLA. So based on the material, whatever material is there, senior officials, if they, who has been authorized by the central government, if they arrest based on the material, whatever is there in possession, if they have reasons to believe, then they can be arrested. And the officials, however, are supposed to inform the accused of the grounds for such arrest. ASAMB means as soon as may be. Yeah. So we talk about ASAP, as soon as possible. But the keyword here is as soon as may be. Okay. So that is a very particular word. So we should remember that. Okay. And every person arrested will have to be taken to a special court or the judicial magistrate or a metropolitan magistrate, depending upon the jurisdiction, within 24 hours. So this is also a very important clause. And this particular act has a provision of bail also under section 45. There are two conditions and that must be satisfied for a court to grant a bail. So public prosecutor must be heard. Okay, and the provision conditions are that the court must be satisfied that there are reasonable grounds that the accused is not guilty of the alleged offense, and if the accused is going out on a bail, then the court has to be like satisfied that they will not commit any other offense. So these are the two conditions. Okay, so these are the provisions which, because of which it is in news, and we will see them in detail. So we have seen the provisions. What are the issues which are, or the criticism against PMLA, that we will see one by one. So the first criticism or the issue is related to that there is no reporting of grounds for arrest is there. So proper reporting for grounds of arrest is not there. It is not reported. Okay. And the arrest is happening, the arrest of a person is happening without ECIR copy. So ECIR is I will discuss the full form also later. So ECIR, if for now you should remember that it is like an equivalent to FIR, and that copy has to be there for internal purposes, for the official purposes. Till the time the investigation is going on, it has to be there for the internal purposes. So it is basically an internal document and it is not given to accused. Throughout the procedures, the accused does not even know the facts of the allegation against him, and the only document which contains the allegation is ECIR. So it is criticized that arrest is happening without ECIR copy, and ECIR only contains the allegations about the with respect to the accused, and accused even doesn't know that, even they don't know the facts of the allegation which has, because of which they are being arrested. So this is one of the criticism. Also the procedures of investigation, the recently the whatever case was going on, Vijay Madan Lal Chaudhary case, so all these provisions, all these criticism was raised against the uh, act. So it also says that procedure of investigation violates the fundamental rights. So it has been argued that the procedure for initiating an investigation, summoning, witnessing, or the accused person for questioning, or for recording of these statements, in fact, confiscation or the attachment of the assets, presumption of guilty, these violate the fundamental rights, and these violates the fundamental rights of liberty, right to right against self-incrimination, and due process of law, due process provision, which are put in place under the CRPC, Criminal Procedure Code. So these are the criticism. And also another criticism is of a strict bail condition. Okay. So these are the few issues which has been raised, or the criticism which has been raised against this act. We will discuss other issues as well. Other issues are related to burden of proof lies with the accused. So, in general, any criminal law, every accused is innocent until proven guilty. However, in PMLA, this burden has been shifted to the accused person. They will have to prove their innocence. So, reverse burden of proof is there. Next is possible misuse of powers which has been given to ED under or the officers under PMLA is also one of the criticism. So there is a strong possibility that PMLA can be invoked against the political rival or dissenter because the process is itself the punishment. The whole process of bail or satisfaction or the arrest itself is like a punishment. So this is one of the criticism. And the last one is that low conviction rates are there under PMLA. So as per data from parliamentary records, ED has registered 5422 cases, means 5422 cases under PMLA, but only 23 persons have been convicted so far. That is less than 0.5% is the rate. So very low or abysmal conviction rate is there. So that is another issue. That is another criticism. Now we will see what Supreme Court is saying with respect to all these in the recent judgment. So in the recent judgment, that is Vijay Madan Lal Chaudhary case judgment, Supreme Court is saying with respect to ECIR. So the criticism was that ECIR is like a FIR, and the accused person, whatever allegation has been put upon, all the details will be put into this ECIR. So the accused person should have a copy, or they should know about the allegations. So what Supreme Court is saying, basically this ECIR is Enforcement Case Information Report. Enforcement Case Information Report. So Supreme Court is saying ECIR cannot be equated with FIR. ECIR is an internal document of ED. So supply of ECIR to accused is not mandatory, and only disclosure of reasons during the arrest is sufficient. It is enough. So Supreme Court has is saying like this. On with respect to arrest, the court is saying that it is not mandatory for ED to disclose the grounds of arrest at the time of detaining an accused in a money laundering case. There is a section 17. This section gives ED powers to enter and search suspected property without judicial permission as well. So the Supreme Court rejected this argument, and they upheld the provision that the arrest is happening arbitrary or for a political rivalry, or the accused should know the grounds of the reasons immediately. So they are saying no, there is a provision where the at the time of detaining of the accused, the ED, there is it is not mandatory on them to disclose the grounds of the arrest. So we discussed about the twin conditions on with respect to the bail. So these two twin bail conditions, Supreme Court is telling it upheld the twin conditions for bail under the Section 45 of the PMLA 2002. It held that the stringent conditions for bail under the Act is legal and it is not arbitrary. And we have discussed that what is the Supreme Court's opinion with respect to money laundering. They are saying it is a heinous crime, and it is as heinous as terrorism, and it is a matter which is against the sovereignty and security of the country. So these conditions, the twin bail conditions, are satisfactory and they are legal. They are not arbitrary. With respect to the quantum of punishment, the Supreme Court is again saying that money laundering is one of the heinous crime, which not only affects social and economic fabric of the nation, but also tends to promote other heinous crimes, because it promotes organized crime such as terrorism, offenses related to drugs and substance use. So it cannot be said that there is no compelling state interest in providing a stringent condition of bail or the punishments related to the offenses related to money laundering. Okay, so it is very much justified and valid. And also they have upheld section 24, which is related to burden of proof. So they have upheld the Section 24, that is reverse burden of proof, the burden of proof lies with the accused only. Okay. So all these things has been said by the Supreme Court in the Vijay Madan Lal Chaudhary judgment. Now we shall discuss about money laundering in general. So money laundering, whenever we say, it has different methods, different forms, and IMF estimates that the money laundering leads to around 2 to 5% of loss to world's gross domestic product. So it constitutes approx 2 to 5% of the world's GDP. Okay, so that is the equivalent data which IMF is saying. Okay, and if we talk about money laundering, it has different forms like smurfing, where the criminal break up large chunks of cash into multiple small deposit, or the currency exchange, or they use or invest in commodities, investing in commodities like gems, golds, or real estate, dealing with real estates, cars, and high-end products. Gambling. So gambling also money is laundered in casinos. So this money laundering has huge impact on economy, society, politics, also criminalization of politics, instability. You can say sometimes it leads to it leads to organized crime. Artificial increase of the prices will happen, so it also leads to inflation. Okay, so all those things, so we are not discussing much about it. Now we will discuss about what is the mean, what steps government has taken, or at different levels what all steps has been taken in order to deal with the money laundering. So the first one being under the legislation. So we have the first law, that is smugglers and foreign exchange manipulator, that is counterfeiting also happens. So Forfeiture of Property Act 1976, that is Smugglers and Foreign Exchange Manipulators Act 1976. Under this also money laundering पे ट्रैक रखा जाता है, and it is addressed. Then, in order to check drugs related issues, so we have Narcotics, Drug and Psychotropic Substance Act 1985, जिसमें मनी लॉन्ड्रिंग के पैसे को कैसे यूज हो रहे हैं उसको ट्रैक करते हैं, and from where the funding is coming, and that is also check is put on that. Okay, then definitely we have our PMLA, that is Prevention of Money Laundering Act 2002. Okay, and further it was amended in 2012, so that is there. Then we have Black Money and Imposition Act, that is full form is Black Money Undisclosed Foreign Income and Assets Act. So Black Money and Imposition of Tax Act is there. Black Money and Imposition of Tax Act is there, 2015. So it is specifically to deal more effectively with the issues related to black money, which is going away foreign, and more stringent norms, penal consequences. This law is projecting, and this law has included the offense of willful attempt to evade tax in relation to undisclosed foreign income assets. Okay, so as a schedule offense under PMLA. Okay, so that way also it is putting a check on money laundering. So these are the legislations in India which are directly, indirectly dealing with the money laundering issues, or the money which is being laundered through different activities. So we have agencies. The first agency is Financial Intelligence Unit, IND. That is, it is an independent body reporting directly to Economic Intelligence Unit, which is Economic Intelligence Council, which is headed by Finance Minister. So you must have read about this Economic Intelligence Council. It is headed by Finance Minister whenever you are reading about your prelims related information. Then we have Enforcement Directorate, that is ED. It is a law enforcement agency and the Economic Intelligence Agency also, which is responsible for enforcing the economic laws like PMLA and fighting economic crime in India. So the main function of ED is to investigate offenses of money laundering under the PMLA Act 2002. Also, we have certain global efforts. Global efforts like we have Vienna Convention, that is the United Nations Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substance. So we have Vienna Convention related to the trafficking related to drugs and psychotropic substance. Then we have FATF, that is Financial Action Task Force. It has been set up by the government of G7 countries, and it puts a check on terror, this terror funding. And time to time they come up with different list, black list, gray list, and often they have been putting Pakistan in the gray list or black list sometimes, in order to monitor that how the funds are being laundered in those countries in order to finance the terrorist activities. Also, we have United Nations Office on Drugs and Crime, which puts a check on all these aspects of the money laundering. Okay, so these are the different categories, legislation, agencies, and global efforts with the help of which we are tracking the money which is being laundered in different activities, be it drugs, prostitution, organized crime, terror funding, and we are putting a check. So Interpol is also there. So a lot of information sharing happens at international level between the countries in order to cooperate with relate to this over the cooperation happens over the issues related to economic offenses. Okay, now we will discuss about the way forward. So whenever you're talking about way forward related to money laundering, do mention about the digitization, which is the process which is going on in India and at international level, where we are tracking the source and the sink or the origin of the money which is being transferred, where it is coming and from where it is going. So digitization is a key, that is cashless economy. Then you talk about taking the role of emerging technologies like blockchain technology, big data analytics, machine learning, artificial intelligence, how we can track the overall flow of money at the national level, at the international level. So that also can be an added advantage where we are roping in the technology in order to monitor the money laundering or the black money or the different forms. So be it hawala ka paisa ho, chahe whatever form it is. Also, a stronger sharing mechanism should be there between the, you can say, interagency cooperation, or most importantly, we should, here we are talking about the international level. One country should, the agencies at in different countries, they should have a stronger sharing mechanism, because once the money is leaving our territorial boundary, then it is very hard to track it. So a stronger sharing mechanism is must, so that we can together put a check on this. So FATF is doing a lot of stuff, lot of work, good work. They are coming up with a common sharing platforms or the portals where the countries are cooperating with each other. And in as a part of DTAA, double taxation avoidance is, agreement, also many countries are signing this agreement of sharing information in order to tackle the money laundering related issues or the tax evasion issues. Also, within country, banks should have a stronger KYC, or the financial institutions which whosoever is dealing with the money, they should have a stronger KYCs in order to put a check on that who is doing what kind of transaction. So what is the nature of the company, from where the money is coming, so that it can be tracked when we have a stronger KYC norms. Also, we should talk about training the human resource in the financial institution to spot the uh, potential areas, the dark areas over the with related to different activities, suspicious activities, and if they are able to identify the money laundering related transaction, then they will detect more such transaction, and they will be, if they are empowered technologically, cognitively, and maybe training mechanism by sending it to them to different countries, also exchange programs as we learn in different aspects, different fields. So that can be also explored, where we need to train our human resource to think in such manner. So if somebody is doing some crime, we have to one step ahead from them in order to think like them. Okay, so talk about all these way forwards, and then you can end your answer. So this is it with respect to today's video. Hope you had a good time, you got good knowledge, and most importantly, you got to know that why it was in news and what Supreme Court has told, and what are the provisions of PMLA and what all we should do. So this is very important topic whenever we are talking about GS3, because there is one specific topic in GS3 which is talking about money laundering. So it is a matter of security. It is a matter of concern, as Supreme Court has also highlighted that it is as heinous as terrorist activities, terror activities. Okay. Okay, guys, thank you so much. We will meet tomorrow in another video with another current affairs issue. Take care. Bye bye.